To assist the attorneys in the water rights litigation that the tribe has entered into on the Truckee River water rights suits, the attorneys found it necessary to have W.F. Ziegler and Associates conduct a 3-year study on the impact of the continuing decline of the water level in Pyramid Lake. Here you see the research building on the shores of Pyramid Lake. In this particular room, U.S. Fish and Wildlife Service is conducting a program to determine the effects of different concentrations of total dissolved solids on the fishes. Each aquarium has either Lahontan cutthroat or kiwi, and the water is set at different concentrations from half
close-up of that now.
After the Lahontan cutthroat became extinct in the early 40s, little was done until around the mid-50s when Nevada Fish and Game began a limited planting program in Pyramid Lake with Lahontan cutthroat, the egg source being Summit Lake, a small, remote lake in northern Nevada. As you see us approaching the south end of the lake, the large delta is present. Here the river enters the lake, but is spread over many acres and is only a few inches deep. The fish usually get stranded and suffocate prior to entering the river. This gives you a good example of the flow of the Truckee River during the month of August. You compare this with the flows above Reno, it will be striking that when you see how much water is being removed prior to entering Pyramid Lake. The lake evaporates approximately 4 feet of water per year, and its sole source of supply comes from the Truckee River. If the river does not make up that 4 foot of evaporation loss, then the lake consequently will drop in level. You can see some of the old watermark lines where the river at one time was higher. Oh.
Mr. Spicer, could you tell us about the background of the Pyramid Lake litigation?
Well, yes. For hundreds of years, Paiute, who were very friendly and generous people, used Pyramid Lake and the Truckee River as a major source of their food supply, and that they relied on the fish that were there. And they invited tribes from as far away as the Utah Territory and up into Oregon and Idaho and the southern areas to share the fishery with them. And they came during the fish runs, which were both in the fall and in the spring, and then the Indians would dry the fish and preserve it, and hundreds, even thousands of Indians used this tremendous fishery, which was one of the world's most abundant freshwater trout fishery, as a source of their food. And but then right after the turn of the century, the 1900s, the federal government decided that they wanted to reclaim the West, and they passed the reclamation laws. And one of the principal advocates of the reclamation laws was Senator Newlands, who happened to be a Nevada senator. And so one of the first pilot projects for the Bureau of Reclamation to establish was the Newlands Reclamation Project, which was largely located on a semi-desert area in another watershed, the Carson watershed, to the south and west of Pyramid Lake. So to accomplish this, namely to reclaim some over 200,000 acres of semi-desert land, they felt they had to divert most, if not all, the waters of the Truckee River away from the Pyramid Lake Indian Reservation over into this other watershed. And of course that killed the fishery, the natural fishery. The Indians were not, there was a court case that the government brought to perfect their rights for the Newlands Project, and the only rights they asserted for Pyramid Lake were agricultural rights for a very minimal amount of agricultural lands on the Pyramid Lake Reservation, which involved some 30,000 feet of water out of a river that on the average flowed close to 600,000 acre-feet. And the rest they contemplated taking away from the Indians over to this reclamation project. And the United States never asserted the right for the tribe to sustain the fishery because the best evidence is that the government knew if they did this, they couldn't have their reclamation project too. So it was a clear case of selling out the Indian interests for the interests of the white majority and for what the government felt was politically expedient at that time. So for the next the reclamation project was begun about 1906, and the diversion of the waters started in earnest around 1910, 1914, and by 1938 the fishery of the Pyramid Lake was gone, the trout fishery. The waters were deprived, the river, the lower river, which flowed into Pyramid Lake, so the fish could not come upstream to spawn. And so by 1938, 1940, the cutthroat trout were dead, and the Pyramid Lake Indians were destitute, and they were in despair. Along about in the meantime, the Indians were complaining, but their complaints largely fell on deaf ears because the Department of Interior was largely controlled in these matters by the philosophy of the Bureau of Reclamation, which wanted to build ever more dams and improve irrigation projects, and these are largely conflicting with Indian rights. But anyway, in 1970, the forerunner of the Native American Rights Fund, a fellow by the name of Robert S. Pelsiger and David Getsis, who were working at that time with California Indian Legal Services, became interested in the plight of the Pyramid Lake Indians, and they encouraged me also to become interested, and we represented the Indians, the Pyramid Lake tribe, and we brought suit against the Secretary of the Interior Hickel at that time, and later it was Roger C.D. Morton. And in 1972 we tried that case on the theory that the government was, by allowing all this water to go to the Newlands Reclamation Project, was wasting the water because the Newlands Reclamation Project uses, for the few acres that they were finally able to irrigate, uses far in excess, uses an amount of water far in excess of that used by comparable irrigation districts elsewhere in the West. And so we won that case in 1973. Judge Gazelle in Washington, D.C., United States District Court, issued a decree that provided a new operating criteria for the Secretary of the Interior to follow to cut down the water use on the Newlands project. The next step, which the tribe could never afford by itself, was to sue some 3,000 water right holders on the Truckee River that had secured water rights under the old decree, which I talked to you about earlier, as well as there were a lot of other parties that were interested on the periphery, such as that they'd received state permits and so forth like that. So most of these parties were all joined, and as well as all the farmers on the Newlands project, and we found ourselves suing 13,000 people. Along the Justice Department and the Pyramid Lake tribe were joined in that action. And that The first thing the defendants did is that they brought a number of defenses, one of which was that the case had already, that the rights, all the rights on the river had already been decided before. And therefore, the tribe, in this old suit that I told you about, therefore the tribe couldn't bring this new action. They were barred from bringing it. And that suit was filed in first it went to the United States Supreme Court, and the United States Supreme Court said that you'll have to try this out in the district court first, and so that case was brought in December of 1973, and we went to trial on just the defense that there had been a prior adjudication, which is in legalese is a res judicata defense. We went to trial on that starting in November, and that trial lasted through, went to trial in November 1975, and that trial lasted through May of 1976. And